We now arrive at one of the most powerful contract writing tools available in Arizona real estate practice, the Additional Clause Addendum. This document allows parties to modify, expand, or replace specific provisions of the residential purchase contract in a structured, legally enforceable format. Unlike informal handwritten clauses, this addendum is standardized, recognized by Arizona Realtors, and drafted to integrate directly with the contract. Most importantly, when properly marked and initialed, the terms of this addendum prevail over conflicting terms in the main contract. That hierarchy language is critical. In the event of conflict, the additional clause addendum controls. Advanced agents must understand not only what each clause does, but how and when to deploy them strategically. Backup contract contingent, upon cancellation of prior contract managing competing offers. This clause is used when a property is already under contract, but the seller wishes to accept a secondary offer as a backup. The backup buyer acknowledges the existence of a prior contract and agrees that their offer becomes primary only upon written cancellation of the first contract. Time periods begin upon notice of cancellation. This protects sellers from losing momentum if the first transaction collapses, while giving backup buyers an opportunity without immediate escrow obligations. Scottsdale example: a luxury home goes under contract. A second buyer offers slightly higher price and agrees to backup status. If the first buyer cancels during inspections, the seller provides written notice and the backup contract activates immediately without renegotiation. Signature of absent buyer, spouse, or co-buyer, ensuring title clarity. Arizona community property laws require proper spousal signatures in many transactions. This clause requires the signing buyer to obtain the absent spouse's signature or provide a disclaimer deed. Failure to secure appropriate signatures can delay closing or prevent title issuance. Brokers must recognize this risk, especially in married buyer scenarios purchasing investment property. Corporate relocation approval, protecting relocation transactions. Corporate relocation sellers often require internal approval after contract execution. This clause makes the contract contingent upon corporate approval, while requiring buyer cooperation for additional disclosures. Buyers incur no additional costs, and the transaction remains conditional until approval is granted. Relocation companies frequently impose addenda and disclosure requirements beyond standard Arizona forms. Non-refundable earnest money, high-risk negotiation tool. This clause converts earnest money into non-refundable funds except under limited cancellation rights, such as inspection period or seller breach. It is often used in competitive markets to strengthen offers. However, it significantly increases buyer risk. If appraisal fails or financing collapses, earnest money may be forfeited unless federal law prohibits enforcement. Gilbert example. In a multiple offer scenario, a buyer offers $10,000 non-refundable earnest money to outcompete others. If the buyer later changes their mind after inspection period expiration, that deposit may be lost. Agents must clearly explain risk before recommending this strategy. Appraisal contingency, waiver buyer, accepts market risk. This clause removes the appraisal protection found in Section 2 of the purchase contract. If the property appraises below purchase price, buyer agrees to increase down payment to cover the shortfall. This is common in competitive markets, but requires strong buyer financial capacity. Lender limitations still apply. Queen Creek example. Buyer offers $450,000 on a property listed at $430,000 and waives appraisal contingency. Property appraises at $440,000. Buyer must bring additional $10,000 cash to closing or risk breach. Appraisal shortfall cap, controlled risk strategy. Instead of full waiver, this clause allows buyer to agree to cover a shortfall up to a specific dollar amount. If appraisal gap exceeds that amount, buyer may cancel within 5 days or waive contingency. This balances competitiveness with financial protection. All cash sale appraisal contingency. Even cash buyers seek protection. Even in all cash transactions, buyers sometimes request appraisal protection. This clause allows cancellation within specified time frame if appraisal fails to meet purchase price. Importantly, contingency expires 20 days after acceptance regardless of whether appraisal has been ordered. Timing control is essential. Wholesaler status disclosure. Arizona legal requirement. Arizona law requires wholesalers to disclose their wholesale status in writing before entering into binding agreement. A wholesale buyer intends to assign the contract. A wholesale seller holds only equitable interest and may not hold legal title. Failure to disclose wholesaler status can invalidate agreements and result in legal consequences. This clause ensures statutory compliance. Tax-Deferred Exchange Section 1031 Strategy Protection. If either party intends to complete a tax-deferred exchange under Internal Revenue Code, paragraph 1031, this clause allows cooperation without imposing additional cost or liability on the non-requesting party. Closing cannot be delayed, and indemnification is provided to protect brokers and non-participating party. Students must understand that exchanges require qualified intermediaries and strict timelines, 45-day identification, and 180-day closing rules. Offer initiated by seller reverse. Offer structure. Sometimes sellers initiate the contract rather than buyers. This clause removes the standard acceptance section and replaces it with seller offer terms. It defines precise acceptance deadline and withdrawal rights. This is often used in counter-offer scenarios or when seller responds to inquiry with formal signed contract. Unrepresented buyer notice documentation protection. This clause modifies delivery provisions when buyer is unrepresented. It clarifies how notices will be delivered and removes broker notice provisions. This integrates with earlier chapter discussion regarding unrepresented buyer disclosures. Survey clause, protecting boundary and title issues. This clause requires a licensed survey within specified timeframe and allocates cost responsibility. It may require ALTA-level survey suitable for title insurance endorsement. Buyer has 5 days after receipt to disapprove. Survey clauses are especially critical in rural, acreage, or older subdivision properties, where boundary encroachments are common. Pinal County example. A survey reveals fence encroachment 2 feet onto neighboring parcel. Buyer may negotiate correction or cancel within survey review period. Water rights and general stream adjudication disclosure, Arizona-specific risk. Arizona is currently undertaking adjudications of Gila River and Little Colorado River systems. If property is affected, parties must execute assignment of statement of claimant and pay filing fees. Water availability must be investigated during inspection period if material to buyer's decision. Rural Arizona properties frequently depend on water rights separate from land ownership. Conflict priority clause, legal hierarchy protection. The addendum explicitly states that if a conflict exists between the purchase contract and this addendum, the addendum prevails. This protects negotiated modifications from being overridden by boilerplate contract language. Proper drafting requires precision to avoid ambiguity, advanced risk management, and broker supervision. Under AAC R428-1103, designated brokers must supervise contract drafting and ensure agents do not misuse advanced clauses without proper explanation. Misapplied appraisal waivers or non-refundable earnest money provisions are common complaint triggers. Agents must document client understanding. Discussion question. When should an appraisal shortfall cap be used instead of full waiver? Answer. When buyer wants competitive strength but limits financial exposure to a defined dollar amount. Discussion. Question. Why does the addendum state that its terms prevail over the main contract? Answer. To ensure negotiated modifications control in case of conflicting contract provisions. Discussion. Question. Can wholesalers enter binding contracts without disclosure? Answer. No. Arizona law requires written disclosure of wholesale status prior to binding agreement.